So good afternoon, and thank you for joining us. This is the first session of what I believe to be our first annual, I think that makes it an inaugural, uh, IP summer school. So this is, like I said, this is the first session of our free four-part webinar series that'll be running May, today through the end of August. I'm Haley Cook, Marketing Coordinator of Events here at Ward & Smith. I'm located in our Wilmington office, and I'll be your moderator for today. You already got started. Sorry about that. Just a quick note, this webinar is being recorded. If you can also find our past recordings under past webinars section of our website. Just a few housekeeping things for today. If you experience any issues with video or audio quality during the presentation, please use the Zoom chat feature and I'll do my best to troubleshoot with you. Our speakers are happy to take questions. I believe we're going to try and save them for the end. So if something comes to mind during the presentation, please type it into the Q&A box that you'll see, and it'll be addressed at the close of the session. But you can type it in at any time, and we'll be monitoring that. Today's session, ooh, sorry, I got my slides out of order, is titled Protecting Your Secret Sauce, Trade Secrets in the Modern Workplace. With remote work, mobile employees, and digital file sharing making trade secret protection more urgent than ever, our speakers will walk through what qualifies as a trade secret, how courts are deciding misappropriation cases, and the practical steps that hold up when things go wrong. Leading today's session, your professors, if you will, are Gavin Parsons and Taylor Pulliam, based in our Ward & Smith Raleigh office. Gavin is a litigator whose practice specifically focus on intellectual property and complex commercial disputes, including trademark, copyright, patent, and trade secret matters. Taylor is a litigation attorney whose work spans commercial disputes, civil litigation, and a range of other contentious matters. I'm sure I didn't do them justice, but I will go ahead and turn it over to you both. We'll turn it over to you now, Gavin, to get started. Or Taylor, excuse me, to get started.
Well, thank you, Haley. And good afternoon, everyone. And thank you for joining us for session one of our IP Summer School series. As Haley mentioned, my name is Taylor Pulliam, and I'm here with my law partner, Gavin Parsons. We're both attorneys in the Ward & Smith Raleigh office. Now, today we're going to be talking about something that affects every single business, regardless of size or industry, protecting your trade secrets. Now, we've titled this session Protecting Your Secret Sauce because, frankly, that's exactly what trade secrets are. They're the special ingredients that give your company that competitive edge. So over the next hour, we're going to cover what qualifies as a trade secret, how theft happens, how to spot it, and most importantly, what you can do right now to protect yourself. This isn't just, a legal lecture. We want you guys to walk away with a practical action plan. So Gavin, I'll let you take it away from here.
Thank you, Taylor. Why are we doing this session specifically on trade secrets and why now? Well, the answer is that the workplace is somewhat different. It's fundamentally changed than since when I started doing this, probably 25 years or so ago. The idea that paper files and file cabinets are really where your secrets are is a thing of the past, although that still exists. But remote work and digital storage have really, and the internet have just been game changers for this area of practice. With remote work in particular, it's got your sensitive information is in a much less controlled environment. And you've got employees at their kitchen tables and home offices, and your files are floating around their personal Wi-Fi networks, personal devices, and places that you just can't see or control. Also, digital storage, again, anymore when your files were locked away in file cabinets and paper, if somebody wanted to walk out the door with them, they had to stand at a photocopier for the whole office to watch. And now they can, frankly, a disgruntled employee can just drag and drop an entire customer database onto a thumb drive or forward it over an email or Bluetooth, transmit it from one laptop to another. Also, another piece of this is that there's been growing hostility towards non-compete agreements and employment agreements. I know there was an effort by the FTC a year or two ago and they attempted to all out ban non-compete agreements, except for narrow circumstances. And although that has been reversed by the courts, there's still hostility at a federal and a state level towards non-competes. And so, to the extent employers in the past could just say, well, my employees really can't leave except in limited circumstances, and um, they can't practice in the same area. So that protects me. You your protection's got to focus more on your information, particularly your trade secrets. And the last reason this is timely and important is that jury verdicts in the last few years in trade secret cases have been very elastic, which means they could be very, very high in the hundreds of millions. Um, and that's what's drawing a lot of attention and scrutiny from businesses. So let's go on to the next slide. Just again to put some numbers on it, there's been cases in the last 4 or 5 years. The Motorola matter was $407 million. The Computer Sciences Corp, $210 million. Insulin, again, 452 million. You see where this is going. The one that really kind of blew everyone away, and it's not on the slide because it's been reversed. Appian Corporation sued Pegasus Systems in Virginia State Court, and a jury awarded them $2 billion. Now, again, that it's been reversed by the appellate courts due to issues with the jury instructions. The Virginia Supreme Court overturned it, actually, I think just within the last month or so, and awarded a new trial. But the damages can be eye-popping. Again, this is not just the value of what was taken, but it's also trade secret damages come from many, many places. And generally it's what did you lose as a business, but also what did your competitor gain? And it's your lost competitive advantage. These have really long-standing, deep repercussions. Um, at any rate, that's the why we're here. Let's talk about the rest of the day, Taylor.
We'll go to the next slide here. All right, so what qualifies as a trade secret? So let's get into the legal framework here. So under the Federal Defend Trade Secrets Act, or DTSA for short, which was enacted in 2016, there are three requirements for something to qualify as a trade secret. So one, it must be information. Now that's a broad category. It can include financial information, technical data, research, business information, engineering data, all of that sort of stuff. Think formulas, customer lists, pricing comp, software code, manufacturing, any of those things can qualify. So one, it must be actual information. Two, it must actually be a secret. This means it's not generally known in your industry, and you or the owner have taken reasonable measures to keep it that way. Now, I want to emphasize reasonable measures because we're going to come back to that in more depth, but the law basically doesn't require perfection, but it does require effort. So one, it must be information, and two, it must have actually been a secret. Three, it must have independent economic value from not being publicly known. So in other words, the secrecy itself is what gives it value. If your competitor knew this information, you'd lose your edge. So it must be information that's secret, and the secrecy of that information is what gives it its value. Now, here's something that surprises a lot of people. Even publicly available information can be considered a trade secret if it's compiled in a proprietary way. So if you spent years building a database that combines publicly available data, but let's say it points into some sort of unique analytical tool, that compilation itself may be protectable. Courts have recognized customer lists, pricing compilations, formula software, and processes all as trade secrets. And in this next slide, we're going to talk about what does not qualify as a trade secret. Now, equally as important as understanding what does qualify is to know what does not. And this is where we often see business owners get tripped up. Now, the following do not typically qualify for trade secret protection. So basic customer list without any proprietary data, If it's just a list of names and phone numbers, that could be something that anyone could compile from public sources. That's probably not a trade secret. Now, if that customer list includes, maybe years of purchasing history, specific preferences or pricing tiers, that's different because it adds that extra step that might make it secret, and that secrecy gives it its value. So another example would be general pricing information. So that's going to likely be widely known in the industry. Anything common business methods without any unique element specific to your industry or your business. The next one's important because it also trips people up oftentimes. An employee's general skills and knowledge gained during employment. Now, this is important. You can't prevent a former employee from using their general skills and expertise. You can prevent them from using your specific proprietary information. So you can't necessarily prevent them from using things that they learned in a general scope, but you can prevent them from using your secret formulas. So let's say a chef perfects, your secret recipe. He maybe can use the technique to chop an onion or the general tools, but he can't use that specific formula from your restaurant. Another example, information obtained through reverse engineering or independent development. Now, if someone figures out your formula by taking your product apart in a legal way, that's not misappropriation. The Typically the key rule that courts apply is they will not protect, or they, excuse me, they will not protect information that is readily ascertainable by proper means. So if your competitor could easily figure it out on their own, it's probably not a trade secret. And that takes us to our next slide.
And before I get into misappropriation, I do want to point out the difference with trade secrets and a lot of other forms of IP. You may have them and not know it. If you want to patent something, you've got to go to the Patent and Trademark Office and file for a patent and ask the United States government for their blessing. If you want a trademark, a federally registered trademark, you have to go to again to the federal government and ask them to give you a registration, and you have to pass kind of an application process. Um, if you want a copyright, you have to file something with the Copyright Office if you want full federal recognition and protection. I mean, there are some common law rights, but with a trade secret, you develop it yourself, you protect it yourself, and voila, you have a trade secret. So if you meet these elements, and there's many businesses now that have information that's valuable to them that they don't realize they have a federally protected trade secret right just by having information that is secret, that they take reasonable steps to keep it secret. They just may not realize what they have. Um, so that's one thing. And again, unlike patents, they don't expire as long as the information is secret and is valuable. You've got a trade secret, and you can keep it for as long as it's valuable. Um, okay, so misappropriation. Um, and we're using the Federal Defend Trade Secrets Act. If somebody acquires a trade secret by improper means, it can be pretty much anything. One example, or if you disclose or use a trade secret without consent, and you receive a trade secret knowing it was obtained improperly. An example of this would be if you hire an employee away from a competitor, and that in discussing coming over to work for you, the employee winks and says, "Oh, I've got, I'm bringing the secret sauce with me." Wink, wink. If you receive that employee, you receive the information, you've received it improperly. And use is very, very broad. If you incorporate that a trade secret into what you're doing in pretty much any way, it its use into your marketing, into your advertising. If you derive any kind of advantage from having that information, it'll count. Now, independent creation and reverse engineering, Taylor's already explained, that is not misappropriation. However, there are we don't have enough time today to go into all of the ways that the courts are now finding improper means. AI is one of those things that a lot of people are, they're trying to find new and different ways to use AI. Um, and again, if AI determines your trade secret using publicly available information, that's probably not an improper means. But if it is employed to if you have software, Taylor's already mentioned that software can be a trade secret if it is say it's put on a chip that is installed in a some sort of widget, and people are not supposed to try to decompile that software off the chip. But if they use improper means and somehow decompile the code off of that chip, either contrary to a written agreement or otherwise, they may have acquired a trade secret by improper means. Um, let's see, next slide. And
And
I and also we do need to again hit again the idea that if somebody unlike a patent, I want to make this distinction clear. If you have two companies in the same market and they both separately come up with the same idea, that is totally okay. As long as nobody took anything from anybody else, you both came to the same idea. It's a great idea, and you develop it. Both of you can have a trade secret at the same time, and it's fine. Unlike a patent, which is exclusive and you get to exclude everybody else from the market, you don't get to exclude people from the market with a trade secret. If you figure it out, congratulations. You get the payoff of your labor. So okay, the two most common misappropriation scenarios. Um, it, the main one, by and large, 75-80% of the time, the cases that cross our desk are employee departures. It is a tale as old as time. The employee leaves for a competitor or decides that they want to do it themselves, and they may go and service customers in a confidential way. They may take your secret sauce um, or some sort of process with them to a competitor. And again, that is by and large what happens. Someone leaves, they go to a competitor, and the competitor may or may not know that they are bringing this information. Or a business relationship gone wrong. That's you have a contractor that is helping you manufacture or service a widget. Um, again, like somebody that's putting software on a chip or programming some sort of product. They decide to share your information with someone else, or you have maybe a business deal merger gone wrong, and you've shared your confidential information during due diligence, and that company violates the NDA by holding on to that information after the deal doesn't close. So those are the two main scenarios. So that's nerve wracking for everybody, but that's generally how it happens. So Taylor, you want to chat about warning signs?
yeah, and I'll add one point really quick before we jump into that too. So Gavin mentioned AI and basically how that is kind of becoming a new field or new area or consideration in trade secret law. And AI is rampant. People are using chatbots like ChatGPT and Claude, and whether you agree with it or not, people are using them. And so the courts have had to catch up to that, and recent rulings have basically found that there is no privilege. So whatever you're putting into a chatbot, if you're looking to try and, misappropriate a trade secret by going around and using a chat GPT or a Claude, all that is discoverable now, and you can get all that information from whoever's inputting that. So just another thing to consider with that. All right, so let's talk about the early warning signs of misappropriation now. Now, one of the most valuable things that we can share today is what to watch for. So these are some common red flags that should make you pick up the phone and frankly call your attorney. Um, so unusual download or access patterns in your company system. So if an employee typically normally accesses 10 files a week and they suddenly download 500 files in a day, that's a red flag. Employees emailing themselves from company documents to personal accounts. Now, this is one of the most common things we see in litigation, and it's often a smoking gun. That doesn't mean that, every time an employee emails themselves something, personal, that there's going to be a trade secret issue. It could just be maybe they're preserving their own documents. But 9 times out of 10, this is one of the first red flags that you see when there is a trade secret misappropriation about to occur. Mass deletion of files or wiping of devices before departure. So if it looks like someone's cleaning up their tracks, they probably are, and that should tell you something. Suspicious timing. So between an employee's exit and a competitor's product launch, competitors suddenly matching your pricing or your specifications exactly. So if they're mirroring you too precisely, chances are they might be working from your own playbook. And then former employees targeting your customers with apparent insider knowledge. So things that they wouldn't have known to sell to their new customers without having worked for you or dealt with your product. And then unexplained access to restricted systems or areas. So to Gavin's point earlier, everything used to be physical. There used to be physical copies of things. And so imagine, the digital version of that, an employee having access to something they shouldn't have. And that's typically a red flag. Now, if you're seeing any of these signs, one of the most important takeaways is that speed matters. So the faster that you act, the more options that you are going to have legally. And delay can actually hurt your ability to get any relief. So if you're, going to court saying this is very important, this is urgent, but you waited months to do anything about it, the courts may wonder why you waited if that harm was so urgent in the first place.
And
Uh, yeah.
I have been on the receiving end of that disappointment, Taylor. I want to point out, and it was even where an employee will take steps to try to hide where they went. But again, courts, if you don't move promptly, they a lot of times they will deny an injunction, and an injunction is what you're going to go to court to seek. In addition to damages, you're going to want an injunction directing that employee not to share the information, to get it back, to delete the information. So what I wanted to say, what actually happens when you call us about something like this? And let me walk you through it. The first thing we're going to do is, although you need speed and you need to get into court, we have to get up to speed and understand what happened, and then be able to advise you. We need all the facts. So in to juxtapose that with the speed, we have to have information. So there's going to be a meeting. Trade secrets cases come up fast. Your clients are generally angry, afraid, upset, and need and want immediate action. But we can't just jump in and crank out a filing. We need to fully understand what your technology is, or what it is they've taken. And unfortunately, we don't understand your business like you do. So we're going to have to drink from the fire hose a bit and get you to explain to us what it is your company does, why this information was critical to your company, what the value is. And this is frankly one of the key steps in any kind of enforcement, is making sure that we understand this, and we truly get the value, so that we can go and then explain it to a court. I've seen rushes to the courthouse before, where a judge has carved up lawyers because they didn't quite fully get what it was, the value of the product was, or why exactly how it had been kept secret. So who should be in the room? The business owner or the lead executive, somebody from the IT department with knowledge of how your systems work. Um, that is probably one of the most critical person in the room, is frankly your IT person. You're someone from your HR director, because you're going to need the personnel file, the employees' employment agreements. They've likely violated a confidentiality agreement with their employment. And while we're here to talk about trade secrets, it is a little lesser mountain to climb if we go into court for you on a breach of an NDA obligation versus a trade secret. Because if we can just simply say, Your Honor, here's a contract. Sue agreed to keep general confidential information confidential, and she didn't do that. That's a lot easier than all these other requirements that Taylor and I have laid out for you about explaining trade secrets and stuff like that. So the other key person in the room uh, that we would tell you where either you need to have one or we're going to bring one is a digital forensics professional. A lot of the, again, cases now are won and lost on whether someone left digital footprints when they did what they did. All these folks are taking information digitally. They're not printing it and photocopying it and walking out with paper. It's digital files. So digital forensics is really the key. Um, then we would put together a preservation letter to the former employee or the company that you think has taken your information. Put them on notice immediately, and then start a dialogue with them. And then obviously, after we get the information, we would go to court and seek a restraining order to prohibit that information from going further, and also to eventually seek access to it and then deletion. So um, the bottom line would be expect lawyers to move quickly, but there's going to be a method to the madness, and there's going to have to be some conversation and some understanding. And the best thing y'all can do is to make sure that you explain to us why the information is key to your widget, and get your IT team with us in the room so we can understand what happened. So that's what it looks like when it blows up. Hopefully you don't get there. So uh,
All right. So now we're going to talk about a more practical part. So what you should actually be doing. Now, remember earlier we talked about reasonable measures. So the law requires reasonable measures to maintain secrecy. They don't expect perfection, but they do expect effort. So one of the things that we recommend, the first one is a written confidentiality policy, and not just, written in a handbook that nobody's going to read ever again, but communicating those policies regularly, making sure that your employees are aware. And so, when you go into court, you can also say, we regularly informed our employees of these policies. There's no way they weren't aware of it. Next, confidentiality agreements with employees, contractors, and business partners. If you're sharing sensitive information with anyone, there should be a signed written document in place before you share that information that protects you, that protects the information. And again, it gives you another leg to stand on in court if and when a scenario like this ever arises. Access controls, limiting who can see what information. Not everyone needs access to everything. Limiting access on a need to know basis typically, is a pretty good safeguard from that information and that trade secret from falling into the wrong hands or ignorant hands that might not even know what it is. We talk a lot about the internet and data and software and the technical side of things, but physical security is still a strong safeguard. Keeping visitor logs for your business, having restricted access zones. Again, this is kind of a physical side of that access control, and that not everyone needs to know everything and not everyone needs access to everything. So digital security, encryption services, VPNs, especially for remote workers, and mobile device management. Clear marking of confidential information. So if you don't mark it confidential, it's harder to argue to everyone that they should have known it was a secret. Um, you just like on the slide here, you see the confidential tabs. Little things like that go a long ways. And when you think about them up front, it's easier to argue them later. Exit procedures. So, have a procedure for when an employee leaves and there's a device return. You revoke access to the systems. Have documented reminders of these obligations. So every time you send a reminder, make sure that is logged somewhere, whether with your IT or your HR. Just have a paper trail. And when someone leaves, you need that process. And then the last thing on the checklist here would be regular audits of security measures and access logs. So just because you have all these systems in place doesn't mean they're going to continue working properly forever. So having those regular check-ins and audits, often catches things that might have been oversight or missed along the way. Now, I want to emphasize that reasonable measures don't have to be perfect. Courts understand that no system is airtight, even with audits, even with all these different layers of guardrails. But you just have to show that you made a genuine effort. If you're doing nothing, you're essentially telling the court that you didn't think that information was worth protecting, and 9 times out of 10, the court is going to agree with that. Gavin, you have any real world examples you want to touch on for this slide?
Mainly, I would say every company is different. And we have represented small companies with 10 people or less. We've represented massive companies. And everyone's different. So what's reasonable for one company or one department of a company is it's totally different. But the main thing is, yeah, you do things in writing. Where we have really it has caused difficulty is where someone has said, well, we told these folks, information was confidential, but it wasn't marked. Or if it's not marked, if it's at least kept, if it's a digital file, if you keep all the confidential sales information in one of those sales databases and everybody and it's password protected, maybe you didn't have confidential stamped on the spreadsheet or the database, but if you had to have a password to get into it, and a handful of people could only access it, and it was limited. That suffices. As long as you can show that you treat this information different than other information at your company, that is the one thing. Again, big and small. If you have reminders to people, verbal reminders are fine, but you need demonstrable written, have a policy, but also have some sort of communication where you've sent something out quarterly or once a year or something that there is a reminder for people. If it's in their training material, if it's in, again, all of these things, it is not a single thing that does it. Usually it is a stack of stuff. Say, because we're going to a court saying, this is a trade secret. Here's why. Here's all these steps that our folks have taken to keep this stuff confidential. That's the main thing. One thing we have sprinkled in some AI because apparently every presentation that everyone does now must have AI. It's written somewhere. Um, Taylor brought up a cautionary tale about using AI with attorney-client privilege. Also, with AI that is public, that's outside of the house, your employees need to be told verbally and in writing and repeatedly, do not put company confidential information into Claude. Do not put it into Chat GPT. Do not put it into some sort of open AI, because other AI is going to learn on that, and that will be a waiver of the trade secret protection in addition to the attorney-client privilege. So every employees are frequently now using AI, whether you let them or not. So that would be something on my list that you would need to add to these checklists, is it make sure you have an AI policy, AI training, and that if employees are using AI, it is only an internal AI that is approved and and you don't plug your trade secret stuff into it. Um, so again, if we can transition into the next slide, you're building a culture of protection. The key thing is make sure your employees understand, they need to know what a trade secret is and why it matters. The checklists are the first step. The heart of this, though, is your employees. And again, this is where I'm most passionate, because I think this is where you can avoid a lot of disputes and problems. If you have employees and you trust employees with this information, then you should trust them when you explain to them the value of this stuff. You need awareness. The employees need to know what is a trade secret and why it matters to the company. So that's another thing, is if you don't recognize that you have trade secrets, you can't expect your employees to necessarily treat them with the care they deserve. Your again, role specific training. Your engineers, they need to understand that their technical documentation requires protection, and they shouldn't be chattering about it. Your sales team needs guidance on handling customer or consumer information and pricing strategies. Folks that assist the sales team, if they've got access, again, these customer sales databases are generally packed with all kinds of notes. It's not just your pricing, but it's all kinds of notes and who the contact is, and does the contact like phone calls? Does the contact like a visit? Do they like Zoom? What are their preferences? How much have they bought? What are their buying habits? What are they not like? Are there cycles to what they do? These folks need to know that stuff is extremely sensitive and valuable, and how to treat it as such. Um, Anytime there's a transition, new projects, promotions, departures, it is a good time to enforce those obligations with folks. Remind them, again, if somebody is going to transition into a role and they've got another employment agreement or something else they're signing, have an acknowledgement that, this is confidential. You've got these ongoing obligations. Um, and again, this the most likely they're going to encounter new information. Um, Again, if someone is also leaving, transition departures are a hot area here. But again, the goal, what you want is genuine appreciation by your employees of the value of what you've got, not just that, well, I warned them, so we can move forward with a lawsuit. Our goal for you all is that you don't have to sue anyone. You don't have to go chase this information down. You do something on the front end to avoid ever having to pick up the phone and call Taylor and I. That honestly, that is our goal. So you really, whatever you feel would be the best to reach your employees in your chosen field, but just trust that they will genuinely appreciate what you have and the value of it to the company. Um, okay, let's go to the next slide, and this is where things can be the most dicey present day. Um, in 2026, remote work and vendors outside the country let's go back one more. There we go. Remote work, that there's not much we can do about it. That folks can on the labor and employment side are trying to help people funnel people back to the office, but unfortunately I think remote work is here to stay. I We enjoy it, it's helpful. But there's key protocols that you're going to have with that. You've got to prohibit any kind of dissemination of company information on personal email, personal cloud accounts. um, no use of thumb drives. This is the If you take nothing else from this presentation, wildly restricting what employees can do with their information in a remote work environment is the order of the day. Um, there are It should be clearly communicated. This should be a bright line rule. There should be no working copies of materials printed at someone's home or outside of the areas. And if you have company issued laptops, that information should never leave it. If you have it in databases or wherever you store it, it needs to stay there where you can control access and you can see who's visited and how often and what they're doing with it. Um, VPNs should be mandatory for remote access. Um, your mobile devices, if folks have personal mobile phones that they use Outlook or something to use on a company email, you need the ability to delete and wipe company data off that phone when an employee leaves, or if an employee leaves it at the bar at the Dallas airport. You don't need that information out in the open. Um, Again, it's critical. And this is something that every business is different. Your security needs are different. What kind of technology you provide your folks with, that everybody's different, but you need to be doing some sort of security protocol with remote work, with mobile devices, because things will walk out the door and it is very, very easy to do. So Again, make it clear what to do, what not to do. There should be no exceptions for this. Um, so, foreign vendors that you might be using for things. There's again a lot of people use companies overseas to do certain things for them. Um, One thing that everyone can do is think carefully about what you are providing folks overseas, and particularly ones that have no U.S. operations or no U.S. presence. That is really tough to enforce if you have someone in China that's very hard to reach by the U.S. court system, and they are doing things with your software that you don't want them to do. If they're a vendor that's supposed to be putting software on chips and they decide to give it to your competitor as well, that um, it's very, very hard to enforce your rights there or potentially Australia or other places. Um, so in your agreements with foreign vendors, do you what kind of audit rights do you have? Is there an ability for you to compel compliance through the court system? Um, is there a way for you to pursue a civil action in the United States if there's a breach? Um, and again, is there a domestic alternative? Is there a company that could perform something similar that's sensitive here that is easier to control or at least reach in a court of law if you want to make them stop doing something? Um, again, written certifications and permanent delete and return or permanent deletion of confidential information. The written certification is fine, but it also needs to be accompanied by a consent to jurisdiction in the United States, so you can reach them with a court system here. These are all crucial and all things that if you have not thought about it, you need to really think about foreign vendors. And do you really need that foreign vendor, or can we find somebody that we can reach with the United States court system?
Two very important areas to take note of. So let me leave you with the headlines here. So trade secrets can last indefinitely. So as long as the information remains secret and valuable, it's a trade secret. Unlike patents that expire after 20 years, your trade secrets can protect you forever if you maintain them properly. So it's a great defensive tool to have. The DTSA provides powerful federal remedies, so injunctive relief and significant damages, as we mentioned earlier with those jury verdicts. The DTSA has a worldwide reach. So if an act in furtherance of a misappropriation occurred in the US, you can recover for any of that conduct, basically countrywide. And to Gavin's point, overseas, although it is a bit more difficult, but you still have that option as compared to some other options that you wouldn't even, be able to get into overseas markets with. Reasonable protection measures are required, but they don't have to be perfect. So you don't need Fort Knox. You just need a genuine documented effort to say that you tried to keep your trade secret a secret. Speed matters, so act quickly when you suspect misappropriation. Any delay at all can hurt your legal position in court. And prevention is cheaper than litigation. So invest in the culture, invest in the training and consistent enforcement. The cost of implementing those protections is a fraction of what litigation is going to cost. And one final point to close this out, Wardensmith's IP and litigation groups handle trade secret matters at every stage. So helping you set up protections, sending, those preservation and cease and desist letters to what Gavin and I do full-blown litigation when necessary. So if you've seen any of those warning signs as we've discussed, or if you just want a review of your current protections, don't hesitate to reach out to either one of us. We'd rather help you prevent a problem, like Gavin said, than fight about one in court. So thank you all for your time today. We appreciate you hopping on and to learn a bit with us, and we're happy to take any questions now.
Thank you guys. Yeah, do we have any, it looks like we did have one question come through. For you, Taylor, companies often hesitate to act because they are not certain a misappropriation has occurred. What is the threshold for picking up the phone and calling a lawyer?
Yeah, and that's a really important question, and it's one that we see all the time. Business owners who wait because they're not sure enough. I'll just be direct. That threshold is lower than most people would think. You don't need certainty. You just need that reasonable suspicion, like we talked about earlier. So if you're seeing any of those red flags we discussed, unusual downloads, emails to personal accounts, maybe a competitor suddenly mirroring your pricing, that's enough to pick up the phone. And here's why waiting is dangerous. So first, you have statute of limitations, 3 years from when that misappropriation was discovered or should have been discovered. So if you ignore those warning signs early, a court may just say your clock started ticking early, and you don't even have a cause of action anymore. Second, we've touched on this a bit, but if you eventually do seek an injunction, asking the court to stop the other side from using your trade secrets, they're going to look at that delay. If you waited 3 months after seeing red flags to act, the other side in the court is probably going to argue that against you and say, was it really that urgent if you waited this long? And then third, evidence disappears. So electronic data gets overwritten, devices get wiped. The longer you wait, the harder it's going to be to prove, and the more expensive it's going to be to prove. You're going to have to bring in more experts to look for that data that might have been wiped, track everything down. So the cost of an initial consultation and that preliminary forensic review is a tiny fraction of what full-blown litigation is going to cost. So think of it like you're going to the doctor when you notice a symptom. Early detection is always better and cheaper than waiting until you're in crisis. So if we look into it and nothing happens, you bought peace of mind. And if something did happen, you bought yourself some time in a much stronger legal position.
Thanks, Taylor. And then, Gavin, one for you. Can you walk us through a real world scenario about identifying the parties where an employee departure led to a trade secret claim? Were there any warning signs?
Typically what happen and I this is a specific case, but also what happens is someone leaves and the remote employee, the company gets the laptop back and they habitually scan the laptop. They check out what the last few things the employee did with the laptop. They catch emails being forwarded to the personal account. They noticed that after termination, the laptop was there were thumb drives plugged into the laptop and information was taken out. So that created a suspicion. And then there was a hesitation also in terms of giving the laptop back. There was a delay. There wasn't a really good reason for it. And that it was little, it started off as little things that weren't readily and quickly explained by a departing employee. And it just sort of snowballed from there. The other problem was that their competitor hired the employee, and the competitor was not aware what the employee had done. And this is one of the things I did want to circle back on is one, we have focused in on protecting your trade secrets. One of the things that you can do when you are hiring people is protect yourself from a trade secret lawsuit. And this is a concern is if you, particularly if you were hiring new folks, that you are real careful in terms of what you ask them, whether they have prior employment agreements, where they're coming from, make it real damn clear that you do not want any information from them or from their prior employer, those kinds of things. Because that case just turned into a nightmare for the new employer who I represented. And it was one of those trying to explain they did not think they had done anything wrong, but they were in some fairly serious trouble in federal court because of something that a person they hired did. So I would also emphasize that if everybody's hiring people in your hiring process, be very careful when you are screening people and telling them what you do or do not want them to do. Do not bring any thumb drives or information with you. That kind of thing. That was a departing employee situation that really turned bad quickly. Haley, I'm not sure if that was the exact answer we were looking for, but that was one that I thought hit on something we hadn't addressed yet.
Yeah, I'll take it. Thank you guys so much. If no more questions, I'll go ahead and wrap us up and give everybody some time back in their afternoon and lunch break. Thank you so much, Gavin and Taylor. I thought this was a fantastic start to the series. Thank you, everyone in attendance today. You'll receive an email with a link to the recording following the webinar and friendly reminder that these do live on our website under previous webinars. So if you ever want to send it to a colleague or reference that, please feel free. We'll help you join us for session 2 on Thursday, June 25th. Ryan Simmons is going to explore patents in AI, what the future of innovation looks like. So once again, like Gavin mentioned, this is very timely about AI and how it's changing the patent landscape and what businesses should be thinking about right now. We're so grateful for your time and participation today. We hope the insights from the session are ones you can put to work right away, and we look forward to seeing you back in class next month. Thanks so much. Have a great rest of your day. That concludes today's webinar.
Thank you all. Thank you, Haley.
Thank you.